New Zealand's rapid transition to a multiculture is causing problems for the law. That's the conclusion of a new and big report from the Superdiversity Institute for Law, Policy and Business, the brainchild of and chaired by the prominent public lawyer Mai Chen. This report is called Culturally and Linguistically Diverse Parties in the Courts, a Chinese case study, with input from the Law Society and the Ministry of Justice. 2,000 cases reviewed, interviews conducted with lawyers, judges, translators, academics and police. We spoke to Mai Chen. Mai Chen, good morning.
Hello.
Why have you applied a diversity template, or what you call a super diversity framework, to the courts?
Because New Zealand is super diverse now, and I think if we are going to hold on to the things that we value, such as equal access to justice and the preservation of our rule of law, it's incredibly important that we adapt and evolve our system. The number of Asian people here is increasing, and actually the third most common place where people are now born in New Zealand is actually the People's Republic of China.
Yeah.
So when you look in Auckland in particular, all you have to do is look at a call-over list, and what you find is that half the people on that list have Asian-sounding names. That's actually a very famous phrase which I probably shouldn't use.
Just to clarify, a call-over list is what?
It's the parties that are turning up in the court. And the courts, once again, are just another area where we're experiencing superdiversity, and it invariably has impacts. For some reason, Chinese parties in particular are turning up in the courts. And, of course, this is causing quite a few challenges for lawyers and for judges and for court staff and for our interpretation system. You have to remember that in terms of the number of lawyers we have that speak Mandarin, it's relatively small compared to the rest of the profession. If you went to an admission to the bar ceremony, those are pretty exciting, all these young lawyers, being admitted, you will find that the names that are being called for these new lawyers is just overwhelmingly super diverse.
But a lot of those new lawyers you describe in your report are at the fringe of law. They're not necessarily in the big firms, they may be way out in the suburbs, and there's a feeling among them that they are disadvantaged in the courts. Yeah?
I was quite distressed by that. It was one thing that I was not expecting to find. I was hearing something I knew about, which is that if you have a foreign-sounding name, we all know you put in your CV and you are 80% less likely to get an interview because they just will apply a presumption. If you've got a name that looks like that, you can't speak English and you don't understand the culture and you've got all of these problems. Yeah. But there was a problem I didn't know about, and that is that what is happening, especially in the ethnoburbs, where there's a disproportionately high number of people from, say, Korea or the People's Republic of China, or who were born in Taiwan or Hong Kong, or there are Asian law firms which are being set up, and they only have lawyers from those countries that speak that country's language and who only service clients from that country. And the result of that is that they feel quite isolated. The big firms now are starting to think, gosh, there are some quite big companies in this country that might come from Asia. So, gosh, we need some people who speak that language. But then what happens is that the client's keen for everything to be done in their language, and the partners get frightened because partners are responsible. And if it's all happening in Mandarin and the advice is happening in Mandarin, then how do you supervise it? So people say, well, don't you all speak Mandarin? I mean, aren't you all Chinese? Well,
yes.
Chinese come from all around the world, and the fact that you might be a Singaporean person capable of speaking Mandarin does not mean that you are appropriately fit to provide quality translation for somebody from rural China.
Yes, that's in your report.
Well, it's just so important, because what we're finding is that there isn't the time in the system to ensure that there's a good fit. The major thing that I didn't realise when I started was that really judges have been much maligned, and actually that the people who need to work a little harder are really the lawyers. When you interview the judges, they say, well, gee, you turn up in court and the first thing you know is there's an interpreter there. That's the first time that the counsel hasn't bothered to tell you. And, there's a lot of information which is simply missing from the judgments, which is highly relevant. For example, where is the person from? How long have they been in New Zealand? Did they come here as an adult or not? All of those things are critical for you understanding their English capability.
Let's go through the report. Major changes needed, say former Attorneys General Chris Finlayson QC and Professor Margaret Wilson in the introduction to your report. Radical change is what we need. For a start, Chinese people aren't used to the law we practice here. What are they used to, and how does this handicap both them and the courts?
I knew it was different, Jim, but I just didn't realise it was so different. They don't have the rule of law in the way that we know it. They don't have independence of the judiciary in the way that we know it. Now, of course, it's evolving over time. The Chinese rule of law evolves in the way that our rule of law also evolves. So it is changing over time. But in criminal cases, for example, mostly the convictions are done by confessions, and in some cases the confessions are able to be extracted by torture, and the understanding now is that judges shouldn't be taking into account confessions extracted by torture. We have a judge. That judge is independent. It's an adversarial system. It's not an inquisitorial process.
Yes.
Whereas in China, it's an inquisitorial process. They're supposed to be, finding out what's been going on. If you come from a background like that, it means that you might behave quite differently in the courts. Also, of course, back there, it matters who you are. If you're a high-ranking official in the Communist Party, if you're wealthy, if you're powerful, of course, none of that is supposed to matter here, and in general it doesn't. And so sometimes it results in parties in the courts from those countries behaving in a way which is not helpful to them in the courts. They might be dismissive of the judge. They might say to the judge, why are you not listening to me? I've told you what the truth is and you have to believe me. Well, of course, in our system you don't. The Chinese way of doing business is often oral. It's via relationships. So what judges are finding is that there is often very little contemporaneous documentary evidence. So they're reliant on the viva voce evidence, the oral evidence, and of course if the deponent can't speak English, it's translated.
As for learning a second language enough to be able to comprehend the language of the courts, your stats are really interesting. Even after years of study, a second language learner only has 3,000 extra words in their vocabulary. So words like credibility, defendant, malpractice, negligence, plaintiff, testify have no hope of being comprehended.
And most importantly, self-incrimination. If you come when you're an adult, it's pretty difficult to become fluent. And, some courts do use a range of mystifying and not common phrases.
Yes.
If you end up in a jury, and remember, we're talking about judges struggling to put all of this together, struggling to determine credibility. I mean, what do you do as a judge? Usually what happens is you've got two lawyers on both sides. They present their case, and you decide which evidence to admit, which evidence is relevant. You come to findings, you make a decision. Contemporaneous documentary evidence is the most valuable, because, people can say whatever they like afterwards. It's called ex post facto justification, but hard to doctor a document. And if you don't have the documents, then you are reliant on viva voce evidence. And if the interpretation's not good, it's a problem. And on top of that, this is only anecdotal because we don't have hard data. But I'm being told by those in the courts that Chinese parties are disproportionately more than European or non-Chinese parties seeking to represent themselves, despite the fact that they may not speak English.
I saw that. Mai Chen is with us, and her report is Culturally and Linguistically Diverse Parties in the Courts, a Chinese case study. There are two Chinese cultural concepts that do not translate well into our legal system. One of them you've mentioned already, face. But there are two of them. And what are they?
It's the way that Chinese people relate to each other, and it's also their form of status to ensure that they are held in high regard by other people. It's relevant because judges will say to me, it's just mystifying. I have two parties in here. They've both got expensive lawyers on both sides, and they're arguing over 10 or 20,000. It's ridiculous. They should just settle the case. But of course, if you look at the way that these disputes are seen back in the countries from which they come, the fact that litigation has been bought by the other party is seen as an insult. And of course, whoever loses the fight, it's a loss of face, so therefore they're prepared to pay more, as opposed to saying, well, look, it's simply not worth it. There's also issues where judges have said that it's very difficult. They have an accused person. The evidence against them is overwhelming, and yet the person refuses to plead guilty. And their reasoning is that if they don't plead, then the judge can't find that they're guilty, which is clearly wrong. In one case, a judge said, look, I'm going to give you home detention, is that all right? And the person refused to say it was all right because the accused thought that if he didn't agree, he'd be off free. He didn't realise that the alternative was prison. I've also had lawyers explain that, they had a client, he was driving too fast, he was chased by a police car, he didn't know you needed to stop. So he just kept going, and he therefore was penalised to a great extent. There was another client that this lawyer had, and what had happened is he hadn't stopped at a stop sign because actually back in the country from which he came, stop signs aren't signs at which you stop. Then they're kind of there for show, really. And he wanted his lawyer to argue that he should not be penalised because actually when he hit the 3 pedestrians, he was actually driving very slowly. There's a range of issues.
And remorse is an important part of our sentencing process now, and there's a reluctance by Chinese people in court to show remorse.
Yes, because that's not what's done in their culture. It's a huge loss of face to do that. Or there was a case where the wife was, I think she was up for assault of her husband. Maybe she stabbed him. I can't remember. But then she showed remorse through her husband. So she told her husband to tell the judge that she was remorseful. Now, the judge said, well, I didn't take that seriously because if she'd been really remorseful, she would have said it to me. But, of course, if you come from a culture where women are 50 cents and men are $1, I mean, when I was young, we played a game at school and you'd call out a number and it was $4 and, boys were $1 and girls were 50 cents. I mean, if that's the culture from which you come, then saying sorry through your husband might be viewed by you as showing the judge that you are really, really serious about being remorseful as opposed to you saying it yourself since you're only 50 cents.
Right,
half price.
I got you. And a woman who had been convicted alongside her husband had her conviction quashed by the Court of Appeal on the grounds that there was not sufficient evidence that she had knowledge of her husband's tax offending, with the Court of Appeal stating the trial judge appeared to have overlooked Ms. Liu's lack of English language capability. So as well as a lack of comprehension, there are serious errors being made as well.
This is very interesting. My sister Mai Chen, who's an Oxford Don, specialises in this area. It's Asian contract law, and she often looks at cases where wives are made by their husbands to do naughty things, and actually judges forgive them because in the Asian culture, wives are supposed to do as they're told. So it's very interesting when you're looking at mens rea and intent.
It's not unusual for Chinese people to complete a major business transaction without a legally drafted contract, as you said earlier, actually, or without a contract at all and without legal advice. And, of course, the English-speaking firms don't like documents written in Chinglish. That's a recipe for chaos, actually, in New Zealand, it sounds like.
So you have to understand, I mean, you are confronted with 2 parties, neither of them speak English, they're representing themselves, there's no contemporaneous documentation, you've got interpreters in, and you're just trying to figure out what's going on. There might be WeChat messages, you're translating little short kind of text-type messages from one language to another language. You may end up with an interpreter who's actually not appropriate because they don't actually come from that particular region.
Yeah.
And therefore they can't get the cultural nuances. And you are supposed to make findings and determine what happened and who is guilty and who's not guilty and what actually went on. The Chinese rule of law is changing all the time, but a lot of these people left their home country a long time ago.
Yes, they did. And, for example, with drink driving, that until recently,
yes, it
wasn't
illegal.
I read in your report, right. And
it wasn't illegal.
So they're used to driving with a few drinks under their belt.
And if you look at the criminal cases, I mean, I just got sick of doing all these pseudo-ephedrine cases, but the difficulty is that is not illegal back in China. Look, we could be talking about any other country. It just happens to be that for some reason, these people have more difficulties than anybody else. And
yes, well, the reason we're not talking about Filipino people or Indian people is that they have better English.
Well, their English tends to be better,
reason,
and also if you're Indian, you're part of the Commonwealth. So, the legal system is more similar.
It sounds very daunting. If a Mandarin-speaking interpreter from Singapore struggles to understand a witness from a remote area in the People's Republic of China, as you have alluded to, because of the nuances of Mandarin, how on earth can our justice system cope with this kind of impasse?
It's difficult, which is why it's important that it's made visible, because otherwise it's invisible and people don't realise that that has the potential to undermine our rule of law. We don't want miscarriages of justice. I mean, God forbid, we're talking about judges. What about juries?
Yes.
And of course, that's another issue. So we've got an increasing number of Asians in New Zealand. They live here. We need the jury to be a jury of your peers. But what is generally happening is that the Chinese are very diligent. They respond to their summons, their jury summons, and they turn up and then they say, well, sorry, can I be excused because I don't speak English?
Yeah.
Because,
but some of them get on juries anyway, don't they?
Well, they do. And I was talking to one judge who said, well, it's that the technique he uses is simply to say, what's your job? What's your day job? And if it's clear from the day job that they actually speak quite a bit of English and relate to a lot of Kiwis, then he puts them on. But of course, it's difficult because if you get halfway through and then the foreman says, oh, by the way, we've got Joe Bloggs here. And he doesn't understand. He really has no idea, or she has no idea what's going on.
The language barrier is also hampering police investigations in criminal cases. They're struggling to get evidence.
I had just a fascinating discussion with both David Johnston and Steve Simon. And what Steve Simon said to me, these are very senior prosecutors at Meredith Connell, and I'm very fortunate that they're both speaking at the launches. But what they're telling me is that they've now got pseudo-ephedrine cases coming out their ears. They've got all of the evidence, and it's all in Mandarin, and it's these little WeChat messages. And so they're going to have to find a translator, because, we're translating documents. And actually the skill of translating, I'm told, is quite different from the skill of interpreting, let alone providing cultural guidance, which is separate again. And so the thing is that they then have to sit down and say, all right, how serious is offending? How likely are we to be able to get a successful prosecution? And then sometimes they have to decide just to let cases go.
And sometimes the judges are suspicious of the quality of the translation and are wondering whether the translator or the interpreter is doing too much interpretation.
So I've been involved in cases where my client had the question put and she said no, and the interpreter didn't interpret it. So I had to stand up and say, I'm really sorry, Your Honour, I shouldn't be interrupting, but my client just said no, it was not interpreted. In civil cases, if you're required to pay for your own interpreter, sometimes it's really difficult because the party who's paid says, well, you should be helping me in Mandarin or their home language.
This was surely all foreseeable, wasn't it, that New Zealand lawyers would swiftly need China capability when immigration began to be ramped up. So have the university law schools dropped the ball here? Have the big firms dropped the ball?
I think that law firms and law schools, like everybody else, are just waking up to the fact that actually our demography has transformed and it's quite dramatic. It's happening.
Mai Chen's report is called Culturally and Linguistically Diverse Parties in the Courts, a Chinese case study. You make 36 recommendations. A number of them seem to require resourcing that currently does not exist, judges more present in pre-trial processes, interpreters more skilled, more present, standby legal counsel in case of need, extra training for judges, training for lawyers. How much will all this cost? This is a tall order.
Look, it is, but there's a lot that can be done that doesn't cost a lot of money. For example, just having a better pre-trial process for lawyers to be much better at representing culturally and linguistically diverse clients. They should do all the stuff that doesn't require much money, yes, including making sure that people get properly trained and get some cultural capability. If there's one thing that they've got to do, they've just got to fix the interpreter system. I mean, at the moment, we don't have a system.
But how? Because they aren't paid enough and we can't get them.
Well, it's true, but, if you've got regulations that were made in 1974 and you haven't increased their salaries since the rate you pay them since 1994, not surprisingly, they're all going to skip off to Australia where there is a system and they get paid more. And on top of that, if you're an interpreter, it counts towards points for residency. Jim, even if we are aware of these issues, I think it is important. I think awareness is important and we will find a way. We need to be interesting these parties in mediation. A lot of these cases should not be going to court. But of course, mediation means different things back in the country they came from. Also, a lot of the materials in mediation are not in their language. They don't know the services provided. And also, we don't have a lot of mediators that speak Mandarin.
And as you say, this is the new New Zealand.
Our children know that.
Yeah,
don't they, Jim?
It's not some sort of temporary arrangement we've got to accommodate. This is how New Zealand is.
I was waiting to see the statistic in the 2018 census about the number of people who don't speak any English.
Yes.
Not a little bit of English, not, just conversational English, like no English. And what the 2018 census shows is that the number of people in that situation is increasing. It is not decreasing. And I knew that. We've got our own shops, and hairdresser, travel agents, you name it. And you can take Mandarin at school, it'd be fine.
Until you got to court.
Yes.
Mai Chen, thank you. It's a very comprehensive report. So when's the actual launch?
Monday.
Monday. Tomorrow.
Yes.
Lovely. Thank you for coming in to talk about it.